Good morning. My name is Bill Zorn, and I've only been with the firm since 1980, although I did get my first, as I was saying to some of the attendees earlier, I did get my first senior citizen discount at Dunkin' Donuts over the weekend without showing ID, so it's a humbling experience if that hasn't happened to you yet. Get ready. I've been with the firm since 1980. I am the co-chair of the Trust Estates Department and spend time both in New Hampshire and Massachusetts, so issues such as domicile and residence have particular importance to clients of mine as well as myself.
Turn on the microphone here. I think I know most of you. I'm Steve Burke. I was the second attorney at the Trade Center office. I've only been at McLane since 1990. Bill hired me back then, and he still lets me work here, so thank you, Bill. And I do a lot of estate planning work for high wealth individuals, usually business owners. I represent businesses, and I still do controversy work, which is where I see this these domicile issues come up. So we'll talk a lot about that, give you some examples, and hopefully, as we go forward, some helpful hints for you and your clients.
So I'm going to start the discussion just with a brief overview and introduction. And Steve, if you can advance that to the next slide, if you might, or happy to do that. So to state the obvious, the reason why we're here is not only what is the difference, but why does it matter? And clearly one of the most important issues from an individual's point of view in terms of domicile and residence is it determines where a taxpayer is subject to the jurisdiction of the taxing authority. And from a trust point of view, there's actually two issues that we're dealing with not only where is the trust subject to the jurisdiction of the taxing authority, but also what state law applies. And today is not the day to discuss differences between state law, but there are clearly differences between states with regard to rules against perpetuity, decanting issues, trust architecture, asset protection trust, so on and so forth. So again, today is not the day to go into those distinctions, but where a trust is resident has that second level of impact. And clearly what we know about the New England area, that there are varying tax regimens between the different states. So clearly where someone is subject to taxation drives a significant amount of tax revenue or tax savings. So sometimes it's very easy to determine where an individual is a domiciliary, where are they present. It becomes far more challenging when the person has two homes. And when I say two homes, a home in two different states. Sometimes that's Massachusetts and New Hampshire. Sometimes that's Massachusetts and Florida. I mean, those are the two typical scenarios that we see. Obviously, in terms of the different tax regimes, you can see that there's a difference between Massachusetts at 5.2% on most income, but obviously very significantly, if you're in the equities or investment world, 12% on short-term capital gains. In New Hampshire, there's no tax on earned income, a 5% tax on interest and dividends, and what's silent there is there's no tax on capital gains. In Connecticut, as you can see, there's a spread between 3% and 6.7%, and in Maine, it's perhaps the highest at 6.5% to 7.95%. When it comes to trusts, as we said, there are multiple different ways that you can be subject to tax, and if one is not careful, it is possible that a trust might accidentally, not intentionally, be taxed in multiple jurisdictions. Now there are some oddball states, and we're not going to go through those. For example, California and Arizona tax on a percentage of number of trustees that are resident in the state. So if all of a sudden a Massachusetts person passes away and appoints his or her brother in California along with a co-trustee here in Massachusetts, you could be subject to Massachusetts tax, and under my example, 50% of the trust income would also be taxed in California. So you can get caught up quickly in a whipsaw at the trust level if you're not careful. From an income tax point of view, again, you'll see the rates. We're not going to talk about how one structures a non-grantor irrevocable trust, but certainly it is possible to create a trust that's resident in New Hampshire that not only is not subject to earned income, which is unusual in a trust, but also no capital gains and no interest and dividends, so literally no state taxation. So where are we going today? We're going to make a distinction over the next 30 to 35 minutes, the difference between domicile and residence. Different states in New England make that distinction ever so slightly different. To Steve's point, if you get into audit controversy, what is the evidence that is considered? We won't get into lawyer terms like preponderance of the evidence or clear and convincing evidence. It's almost Brady-esque and Deflategate. We won't get into those sort of subtleties.
It's too soon, Bill. It's too soon.
It's too painful. And in any event, and then we'll highlight some typical issues that we see confronted by individuals and trusts. So that's the overview, and then jumping into the substance, we're going to have Steve start with the individual domicile and residence issues.
So I'm going to talk about individual issues, then Bill's going to come back and talk about trust issues. But I want to start with an example, a real life example of one of our clients who, very successful business person, actually came to this country from France many years ago, landed in Connecticut, started a wonderful business, but started it in Massachusetts while he lived in Connecticut. And while he was in Connecticut and started the business, he actually created an irrevocable trust. So Connecticut resident, Massachusetts business, creates an irrevocable trust, puts a piece of his Massachusetts business into it. Mistake number one. Then his business in Connecticut continues to thrive, so much so that he moves to, his business in Massachusetts continues to thrive, so much so that he moves to Newton. Sells his Connecticut residence, now is a Massachusetts resident running a Massachusetts business with an old Connecticut irrevocable trust. Business continues to grow, hops the border, opens an office in New Hampshire, in Salem actually. Continues to grow further, so he has an office in Mass, an office in New Hampshire, and then he says, you know what, I'm going to move to New Hampshire. So he builds a house in Wyndham and moves in. Mistake number two is that he kept his house in Newton. So has a house in Newton, which his wife loves, has a house in Wyndham, which neither of them really like that much. A business that's located in Massachusetts and a business that's located in New Hampshire. Then sells the business. And when he sells the business, Connecticut successfully gets a piece of the gain because it's in an irrevocable trust, and when he was a grantor of that trust, he was a Connecticut resident. Massachusetts argues that he never left Massachusetts because of his Newton residence, audits him, and gets a piece of the gain in Massachusetts, and New Hampshire says, you know what, you're admitting to be a New Hampshire resident, we're going to get you for some of your interest and dividends tax. So he gets whacked in 3 states on one gain, on one transaction. And with some planning, he could have avoided at least 2 of those 3 states, maybe all 3 if he had done it correctly. But in any event, that's just one example of what Bill's talking about, where you can get whacked by more than one state without really realizing it's going to happen. So states are starved for revenue, and each state wants to tax residents that are kind of located in the other state. And we see that a lot. The 3 states that we're going to focus on today are Massachusetts, New Hampshire, and Connecticut. And if you look at this slide, you can see, actually, I guess I should watch the next slide. I'll leave it for this in a second. The real issue here is the concept of domicile. And domicile is, I think as Bill alluded to, the concept of where you are for purposes of taxation. People often confuse this with residence. It's not residence. Right? Domicile is a different concept. Really what it's about are 2 things: where you reside and where you intend to reside permanently. So it's a subjective test, it's what you're thinking about, but of course from an audit perspective, all subjective tests are determined by objective facts. We're really going to focus on the objective facts, everything from where you actually have your house, where you buy your groceries, etc. But it really can be quite frustrating determination because of the number of factors that states look at. As you can see from this slide, each state does it a little bit differently. Massachusetts and Connecticut have a statutory definition of domicile or residence, and New Hampshire has no statutory definition, but rather a Supreme Court case which deals with voting and where you are a resident for purposes of voting, which is used for purposes of taxation. So if you look at the Massachusetts statute, it really focuses on two things. A permanent abode, meaning you need to have a physical residence, whether it's owned or rented in the state, and an intent to remain there. Again, the tricky part is when you have more than one residence, but it's really, that's really it. And Massachusetts focuses on a set of facts and circumstances. So in the materials, Massachusetts put out, which is actually fairly helpful, this legal and resident guide. And if you go through that, it's frankly some great information, and I would say self-serving from the Massachusetts perspective, examples of who is a resident and who is not. New Hampshire, as I said, has a New Hampshire Supreme Court case, and it is delightfully short, so you can read this in about 3 minutes. But it's called Every versus the Supervisor of the Checklist, and Bill knows more about this case than I do, but it's essentially a case not about taxation, but really about where you are for purposes of voting. And then the third handout in your materials is the Connecticut statute, which is, I think, fairly Byzantine in nature, very difficult to read, and we'll go through some of the highlights of that as well. But again, 3 states with 3 somewhat different approaches, all getting at the same issue, which is domicile with a permanent place of abode and a subjective intent to remain there forever. That's the test. So really when we see the challenges of domicile, usually it's not where people don't move around, but the challenges are really when you want to change domicile. Again, our client that was in Connecticut/Massachusetts getting into New Hampshire. And we like to think about this, we like to think about it as 2 parts. First, getting into the state you want to get into. So in my example, getting into New Hampshire, having a place of abode there, intending and objectively evidencing your intent to remain there. But the second part of the test is getting out clean, getting out of Massachusetts clean. And that's what the problem was, and that's what we usually see is the case. So again, getting in and then getting out of the old state clean. So it's really important. And states are looking for sometimes kind of impractical results, which is a complete abandonment of where you were before. And that's often not practical, especially if you're going to retain that residence. And frankly, it's not required by statute. But if you do represent a client or work with a client that's going to continue to have that second residence, you really have to focus on those other ancillary facts, like where you live, where you conduct business. And we'll talk about that as we go. So when you look at the statute in Connecticut and Massachusetts, and you look at a case in New Hampshire, it really comes down to what lawyers like to refer to as facts and circumstances, which is really, so what are you doing? What are these individuals who are in one state or another actually doing in life? And we try to break these down into 2 different sets of facts and circumstances. One is family and business, and the other is daily activities. So family and business, daily activities. So the first slide here is family and business, and really the first thing that happens when you're audited in one of these cases is the states say, where's your home? Where is your physical residence? And that's really may seem silly, but remember that if you've got 2 residences, it's hard to distinguish one versus the other. But it's important to again, focus on where that person lives and where they reside, and frankly, where they keep the stuff that matters to them. The way the states look at this is that there is a group or a segment of your, or subset of your property that you only, the important stuff that you keep only in one house. It's the house that you live in forever. That may not be true, it may not be the case, but that's the way they look at it. So the first thing they say is, where do you live and where do you keep your valuable possessions? Where are your heirlooms? we think that must be your residence. That must be your domicile. The second thing that they say is, so where's your main office? Where do you work out of? What's the proximity of your house to that main office? So family and business. That's the first line of analysis in a typical domicile case. Really important to think about that when establishing domicile, and more importantly, when you're trying to get out clean from the old state. So the second part of the factual analysis really gets to daily activities. And this is really, I think, the most frustrating part of a domicile audit. This is all the stuff that the Commonwealth of Massachusetts or the state of New Hampshire or the state of New Hampshire looks at. They really get into an incredible level of detail. If you look at the handout from the mass.gov site, you'll see a laundry list of factors. And what we did is try to go with some of the more basic ones, some of which would say, of course that's the case. But in every one of these situations, we've had clients that have not quite done it perfectly well. That's what makes them great clients. One of the facts that you may think is self-evident, but really we see people not paying attention to is, so what address do you put on your federal tax return? And you may think, of course I put it on my residence at home, but it's often the case that you don't want correspondence with the IRS sent to your residence. You want it sent someplace else. And we've got a situation right now where the person clearly is a New Hampshire domicile in all cases, but he happens to have a vacation home in Maine, and that's where he likes his personal mail sent, and that's where that's the address he put on his personal income tax return. It is so difficult to explain to the state of Maine that was really as a matter of convenience. So again, simple things like that are important. There's some that are also, of course, self-evident. Where you're registered to vote, where your automobiles are registered, where you have your driver's license, and again, some of the ones that we really focus on are making sure that your estate planning documents are updated and where you reside for purposes of recreation and pleasure. Two of the ones that are often very, very difficult, which and again I think are very unfair, are one, where you retain or maintain your professional relationships. Where are your advisors? So in our situation with this guy that was in Massachusetts, moved to New Hampshire, he kept all of his financial, retaining all of his financial advisors in Boston. It makes perfect sense. He was still 50 miles up the road. But the state of New Hampshire, when dealing with his interest and dividends tax return, argued that, well, that was irrelevant that he stayed down there. The Commonwealth of Massachusetts said, look, you kept all your professional relationships in Massachusetts. You still go to the doctor in Massachusetts, which, by the way, for someone in southern New Hampshire is very, very common. Again, very unfair, but it's a fact that you're really going to have to deal with. I'll talk about the location of charities in just a second, because Massachusetts has a fairly interesting rule with respect to that. So then, just jumping to but the Massachusetts system of taxation itself. Remember, and again, I'm sure most of you know this, that Massachusetts imposes tax not only on all of the income of the domiciles, people who are domiciled in Massachusetts, but also on Massachusetts source income. This isn't a seminar about Massachusetts source income. I just want to mention it for a second because Massachusetts is very aggressive in this regard. If you earn income in Massachusetts, and it's paid to you after you no longer are domiciled in the state, the fact that it's earned here generally means it's still taxable here. So we've seen a lot of folks who have sold their businesses, have deferred comp arrangements, all of the income of which was earned while they were domiciled in Massachusetts, moved to Florida, moved to New Hampshire. Guess what? That income is still subject to Massachusetts taxation despite the move. Massachusetts defines, as I said in the statute, residency or residency to be domiciled under the traditional permanent place of abode and counting days. So I want to focus on the permanent place of abode for a second. It really must be permanent, and that's often where these objective facts come into place. We've got another situation, a case where the taxpayer, at least in our view, never had a permanent place of abode. They had a temporary assignment in Massachusetts, just happened to cover a few different years, but they only rented on a temporary basis. The Commonwealth is saying was that rental is a permanent place of abode. Our argument is, look, this guy never sold his house in New Hampshire, continued to spend as much time in New Hampshire as they possibly could, but temporarily was in Massachusetts for this temporary assignment. And if we could wind back the clock, what we have done is have his employer say in some type of correspondence, this is a temporary assignment. You will be returning to your permanent assignment back in New Hampshire. But again, we can't wind back the clock.
So Steve, let me give you this hypothetical. If a client who lives in Massachusetts then builds or buys a home in New Hampshire, the wife does not want to give up that house in Newton, Wellesley, Weston, etc. And so what happens is the parents give the home to the children, and then the parents rent back the home for 5 months. Do we have they don't own it, they only rent it on a temporary basis. Is that a way to avoid the permanent abode?
I think it's a good start, but probably not actually, because your rental versus owning really, I mean, the statute's pretty clear that there's a limited distinction. I think you'd still have to go back to the objective facts. When they sold it to the kids, did they take their stuff? They left the kids' trophies, but they took all their own stuff and moved it to New Hampshire. Did they do that? And did they change all the other things that you normally change? Did they change their estate planning documents? Did they change their car registration? Did they change did they register to vote in New Hampshire, et cetera? Did they do all those things? If they did, then I think it's a better case. But one of the most difficult facts is that it's the same house. And when you deal with the agents from the Commonwealth Department of Revenue, they look at you and say, look, this is the same house. You owned it at one point, you're now renting it, you never changed. And as I'm going to talk about in a few minutes, one of the things that the agents really focus on is, and I know Bill has had this experience as well, where do you shop? One of the problems we had with our guy who moved to Massachusetts and his wife loved the home in Newton, but not so much in New Hampshire, was that they continued to buy all of their groceries in Newton. They continued to go out for dinner only in the greater Boston area. Not that the restaurants in New Hampshire are awful, but that's really what was the problem. They continued to be there. So that's again, the Massachusetts rule. And I'm going to go quickly through this slide because it really is the same thing. Permanent place of abode, counting days. Those are the two big things. Permanent place of abode, counting days. Do you want to cover the New Hampshire?
As Steve indicated, there is not a statute in New Hampshire in terms of the distinction between domicile and resident. There is the statute up here that talks about resident, and particularly in the voting sense. And again, it's truly a facts and circumstances situation. The one point I'd point out is spending more time in New Hampshire than any other state. Unlike Massachusetts, where they're talking about 183 days, this contemplates a situation where you could end up in a situation where you're spending more time in New Hampshire, but it's not 50% of the time. The case that Steve has referenced, Every versus the town of Madison, in that case, it was a Cambridge school teacher and was required to be for his job 140 days in Massachusetts teaching, but then came north every weekend, spent time in the summer, so on and so forth, but didn't rise to the 183 days. And with the controversy, you can imagine that any teacher that lives in Cambridge probably doesn't vote the same way that the people in Madison do, and so that there was a motivation from that point of view, as well as a few other economic issues where the town of Madison really didn't want this couple to establish residency, but ultimately the Supreme Court said that indeed they were maintaining a home, so on and so forth. So that's perhaps the biggest distinction that you'll see on that. And clearly, the last or next to last bullet, employment in New Hampshire are within a ready commuting distance, because that's acknowledging that there are plenty of people that live in New Hampshire but commute to Massachusetts, and that is not going to undercut the determination with regard to residency.
Connecticut is a unique state. I hope I'm not offending any Connecticut residents when I go through this. And we'll talk about the trust domicile or situs issue in just a bit. But Connecticut is one of those very aggressive states with respect to domicile. And again, it's a statutory analysis. And if you look at their statutes, a little bit different than Massachusetts in that there's a definition of a statutory resident and a statutory non-resident. And in our experience, if you don't fit within the statutory non-residence, there's almost a presumption that you're a resident. So again, the focus continues to be on this permanent place of abode and then counting days. In Connecticut, as you'll see on the next page, they really are aggressive with respect to how you count days. So unless you can prove that the only reason you're in Connecticut is to just pass through, they're going to count that day as a day in Connecticut. So again, very, very aggressive statute on its face, and also very aggressive enforcement of the statute as well. There is, in almost every state this is true, but there's a federal law which allows for members of the armed services to be deemed to have not lost their residence when they're assigned to different posts in different places. One of the things I just want to mention briefly, Bill, I thought was alluding to this when he gave me the example, and that is spouses can have different domiciles, sometimes for the sake of the marriage, sometimes for tax purposes. But you can actually have spouses that file and live in different states. And we've got many situations where that's the case. And again, you've got to really think hard about whether that filing separately makes sense from a tax perspective. But usually, if they're high wealth individuals, they're already in the top bracket. I really would look hard at that, not only from a domicile perspective, but also from a kind of a defensive perspective if you've got an aggressive tax return filed by one spouse or the other. And that can be true from a state tax perspective as well.
And the issue that I ran into was very similar to the fact pattern that's about. We had a high-profile employee. There was deferred compensation. The couple moved to New Hampshire and constructed a new home on Swan Lake. Unfortunately and regrettably, the wife developed a very aggressive form of cancer, a condominium in the Boston area. So they count in as it added his time and her time together and collectively pushed it over the 183 days, and they were filing a joint return. Obviously, at one point there was a discussion, what do you think the Boston Globe would say about what you're doing? And the response was, why don't you go talk to them and find out? I mean, they didn't blink.
Care less.
Yeah, and so they can and will look at both separately. Ultimately, we talked about filing separate returns and so on and so forth and trying to break that so neither spouse was over the 183 days. But they will be creative and they will be aggressive in uncomfortable situations.
Yeah. That's an amazing case. So just to jump to some typical facts, just to wrap up the personal domicile discussion. These are some of the gotchas that we see, and again, many of these I'm sure you've seen before, but when you're representing folks in these domicile cases, there are a few things that you really have to watch out for. Again, the one I'm beating a dead horse deader here is that maintaining two domiciles, you really need to be able to show which one is your permanent abode and move your important stuff there, and then of course register your vote and do all that stuff in that location. Again, I think it's unfair, but states will continue to look at where you maintain your professional relationships. Again, I think the case that Bill just described is frankly outrageous. I mean, it is so common for someone in New Hampshire to go for important treatment, cancer or otherwise, in Massachusetts. Why wouldn't you? Some of the best hospitals in the world, and for that to be used against you in a domicile case is just, I think, disgusting. Sorry. But in any event, that's really one of the factors that all the states continue to look at. The other one that got our Connecticut guy that moved to Massachusetts and then New Hampshire is credit card purchases, where you spend your money. You know, in this day and age of electronic commerce, your fingerprints, your footprints are wherever you were electronically. And so it's really, really important to give that some thought. I wanted to say to the guy, for God's sakes, just get your spouse a separate credit card. You know, then you'll be able to distinguish between what you're doing and what she's doing. And but in any event, that didn't happen. So watch where you buy your groceries and your gasoline and your meals. And the one that we see a lot, of course, is that the states will ask for your Easy Pass records, and they will get them. And your Easy Pass records, of course, show where you drive. And we've actually had clients give up Easy Pass because they didn't want to be tracked. We've had other clients, and again, some high wealth network individuals do this. They actually keep a daily log of where they are, and make sure that with records they can show where they are each. Yep.
And it sounds like eventually Big Brother is going to want to put a GPS in our forehead, right?
I don't know if you've ever heard that, but yeah, a GPS in your forehead is absolutely common. Yeah. Yeah. So one of the things that the states really want to know is where your car is, because they think that's where you are. Again, that's why for some ultra high net worth individuals, they literally hire services to but to document where they are on a daily basis. And again, it's important if you really want to do this right, to make sure that your calendar, because that's one of the other things that the states will look at. Show me your calendar, which of course is electronic at this point, where you are on a daily basis. Really important. Again, the other one that I've seen the last couple of years that I've not seen before is looking at return trip vacation tickets. So the states, the last time was in New Hampshire audit, were looking at how you booked tickets. You know, in this situation, the client booked tickets leaving from New Hampshire and returning to New Hampshire. Now, our story is that the New Hampshire Manchester Airport just is perfectly convenient for him, which I think is the case. But he was unable to show that he actually then left New Hampshire and went back to this is a case where we wanted to be out of New Hampshire, Massachusetts. But where you buy your tickets and how you ask for the return trip can be very, very important.
Well, that airport has Boston in the title.
Yeah, that's just for marketing purposes. That's just so we can get you people on the road.
And just two other items just to piggyback on that. In terms of vacations, we've had a situation where the question is, where do you spend your holidays? Because isn't it frequently your holidays are at the home, and so where those, and that's obviously something that you can control fairly easily. And there was, we got to a neutral position on one of our situations because during the December holidays, they always chartered a boat down in the British Virgin Islands, and so we got to neutral on that. But they actually do want to know where it is. The other thing that you can control, if indeed you're looking at a second home, I won't say which one is primary, they look at square footage, and they also assume that the bigger house, bigger is better, that's where you must be living. And then they want to know if there's that second home, how many bedrooms? Is there a bedroom for every child? Because we've had the argument that, well, the original home had a bedroom for each child, and now you've downsized and frequently the children aren't there at the same time, so there's not necessarily a bedroom for every child all the time. And there's whatever sort of holiday shift that goes on within the family, but they're going to look at, you know, vacations, where you're spending them, and not only where you're returning to, also the square footage. So if someone is in the process of making that transition and they haven't yet bought that house, those are conversations that you might want to have with them.
So this way, we're going to leave the concept of individual domicile and move on to trust domicile.
So within the trust situs issue, We're going to focus first on Massachusetts, and as you can see on this slide, there are actually obviously two types of trusts. Trusts that are set up during your lifetime, the inter vivos trust and testamentary trust. And the testamentary trust issue, which is at the bottom of the slide, is certainly probably the easier one to wrap your head around, which is a testamentary trust is a resident trust in Massachusetts if it's created by the will, and let me add, or a revocable trust of a person who died a resident of Massachusetts. So you're really just piggybacking on the concepts that Steve has highlighted before in terms of are you a resident / domiciliary of Massachusetts. When it comes to inter vivos trusts, and this also added in the word irrevocable, because clearly a revocable trust is going to track with the domicile of the underlying grantor or creator is. But if you have an inter vivos irrevocable trust, then that's only taxed when there is at least one of the trustees who's an inhabitant, not necessarily a resident now, but it's a new term here, an inhabitant of Massachusetts, and then also, in addition, at least one of the trust creators, the grantors, must have been a Massachusetts resident during at least part of the tax year when the trust was created or at the grantor's death. So if New Hampshire resident creates an irrevocable trust and picks a Massachusetts-based institutional trustee as the trustee, we have a non-issue because it's a New Hampshire resident establishing it. The real issue is if you have, for the purpose of discussion today, if you have a Massachusetts resident establishing a trust, then clearly whether or not the trustee or a trustee is an inhabitant of Massachusetts is the critical question. Then we've got a statute in Massachusetts, Chapter 64, Section 10A. Question.
Are you going to explain the difference between an inhabitant and a resident?
Yes, and actually that's what the statute is going to get to.
Thank you.
And just so where we are is just to start with, as I mentioned, if you have a trust with a Massachusetts grantor, you can avoid the Massachusetts tax. And let's start with an easy one. By appointing a sole out-of-state trustee. Again, the statute says if all you need is one be a trustee if you're a Massachusetts grant. Clearly, if you have a New Hampshire trustee, then the question is, there's no definition in the statute for a corporation. What does it take to be an inhabitant? Silent. And so there was a case that came out, and we'll talk about it on the next slide. Don't quite flip it yet because I want to get to this gentleman's question. Is where there's a corporate trustee, when are they an inhabitant? And so to your point, what is an inhabitant? The definition is any natural person domiciled in the Commonwealth, and any natural person who is not domiciled in the Commonwealth, but also has, and here we go back to what Steve was talking about, a permanent place of abode in the Commonwealth, and spends an aggregate of more than 180 days of the taxable year in the Commonwealth. So again, if you have an individual, you actually, it's important to educate that person, because if they are part of the time in New Hampshire, or part of the time in Florida, or part of the time out of state, in theory, you could have your trust flip-flopping from year to year based on how much time that person spends in Massachusetts. So that needs to be a thoughtful selection when you're dealing with a Massachusetts resident who spends time in and out of the state. So then on June 10th of this year, there was a appellate tax court that came down, a very interesting case. And this involved, obviously, a high-level institution, Bank of America, that is the trustee of a number of different trusts where there are Massachusetts grantors. The question was not who were the creators of the trust and whether or not they were Massachusetts residents. The question was Bank of America a Massachusetts inhabitant. Bank of America pointed to its corporate structure, its corporate charter was not in Massachusetts. You know, the headquarters of Bank of America is in North Carolina, so on and so forth. And the court said in that case, and they went back to, was there a permanent place of abode in Massachusetts for Bank of America? And they pointed to, and I'm gonna lose the number here, but something like 472 branch offices. It was north of 400. And certainly they were there, 365 days a year. So not only were they an inhabitant, they had a permanent place of abode in terms of their branch offices, but they were conducting business within the Commonwealth. So in that case, the conclusion was Bank of America was an inhabitant, again, even though there's no statutory definition of corporate inhabitant, and therefore all the trusts where there's a Massachusetts grantor administered by Bank of America are taxed here in Massachusetts. Now, another question.
Yeah, if you don't want me to ask, I won't.
No, well,
Okay.
well,
Good. My question is, would it have made a difference if the trust administration had been conducted out of state in New York or North Carolina or wherever, but not in Massachusetts? And you've still got your 472 approximate locations in Massachusetts where Bank of America is conducting business.
my gut reaction is that the department would say it doesn't matter.
What do you think the court would say?
I
I know that's what the DOR
Well,
would say.
we know what this court said, yeah.
Yeah, I would say that they are gonna side with the taxing authorities in that situation. I think the better solution would be, quite frankly, to establish, and there are institutions that are doing this, a separate, standalone, I'll call it non-depository trust company or otherwise, where the administration is taking place outside of the state of Massachusetts. And we'll jump into this, and I'm noticing that our time is going quickly. So if we shift to the next slide, so trust situs from a New Hampshire point of view, interestingly, focuses on what does the trust say? And if the trust says, and you can self-define where the trust is situs and what governing law applies, those are two different items. But if the trust designates that there's a certain situs, and let's say for the moment it's New Hampshire, and if the trustee's principal place of business, going to your point, principal place of business, not a place of business, but the principal place of business is located in that jurisdiction. Or obviously if it's an individual, the trustee is a resident of the designated jurisdiction. And then here's an interesting part, or all or part of the administration of the trust occurs in that designated jurisdiction, then the instrument will control the situs. Now, as Steve is saying and reminding us, there's two parts of this issue. You have to get out of one jurisdiction and into the other. So this is the definition. How do you get into New Hampshire? You've still got the issues of, in order to make sure you don't get whipsawed, you've got to make sure you get out of Massachusetts. So we have to just be mindful that if we're trying to get out of Massachusetts, we've got to look at the Bank of America case. That's the only case we have at the moment. It goes on to say what happens if the trust instrument is silent, and I'll just, in the interest of time, I'm going to leave that for another day. It's also important if the goal, now I'm from tax situs to governing law. Again, if now what the goal is to have a trust that goes on, whether it's to take advantage of the repeal against the rule of perpetuities, or to create, or to take advantage of different decanting laws that are different than the Kraft case here in Massachusetts, so on and so forth. Not only do you, from a size point of view, but you have to be able to change the governing law. And in Massachusetts, there are several cases from our Supreme Judicial Court that says governing law, unless stated otherwise, is a material purpose of the trust, and therefore you can't assume that just because you change situs, that governing law is going to follow along. So you have to look at the statute and make sure whether or not you can change the governing law as well. Let me say that you can also get into situations, if you look at the statute in New Hampshire, it says if the trust is silent as to governing law, the law of the jurisdiction having the most significant relationship to the matter at issue will govern. Well, again, that probably gets back to facts and circumstances. So to cure that, as of October 1, it says without precluding other circumstances under which New Hampshire has the most significant relationship, it will be deemed that New Hampshire will have the most significant relationship to the matter if, under the terms of the trust, New Hampshire is law governed, and the trust has its principal place of business. So you could end up in a situation where you have a Massachusetts grantor, you could have Massachusetts beneficiaries, but so long as your trust says it's a New Hampshire trust and you have a New Hampshire trustee with its principal place of business in New Hampshire, you can move to New Hampshire, even though one could argue that the most significant relationships are still Massachusetts grounded. So questions that we have that as you're looking at the trustee structure, and remember going back to Massachusetts, if you got a Massachusetts grantor and a Massachusetts trustee, you could have Massachusetts taxation. Well, what happens if, and if I can just flip the slide, in this new era of open architecture, what happens if you have an investment advisor or an investment trustee? Is that a trustee? What happens if you say it's a distribution advisor or a distribution trustee? Does that distinction, which sometimes is a distinction without a difference, matter? What happens if you have a trust protector? That may or may not be a fiduciary, but is that a trustee? And some people are saying, let's keep all of the trustees out of state, but perhaps if we create a single member LLC owned by the trust and all the investments are dropped down into that single member LLC, and then you have Massachusetts inhabitants be the managers, and let's just say for that point it's marketable securities for the moment. Have we got out of Massachusetts? Because in terms of strictly titles, we don't have a Massachusetts trustee, even though we may have someone in charge of controlling Massachusetts investments. So those are areas worthy of discussion and worthy of consideration. And to be quite frank, at the moment, we don't know the answers to those questions, but we certainly have some ideas on how best to structure those arrangements.
I think Bill raises a great point with this open architecture. I think we've been seeing more and more people establish trusts with various players within the trust itself, and really care should be taken to figure out what their role is, where they reside, and really whether you need them or not. And frankly, if you don't need them, whether you can get rid of them. So that careful trust drafting and thoughtful trust drafting is just so critical. But the flip side of that is there's some amazing state tax planning that you can do using trusts now. It's just, it really is a brave new world. Yeah.
Question regarding the investment advisor. That applies to being my investment advisor is my son-in-law, but he's not my trustee. My daughter is. She's the trustee of my estate, my trust. So would there be any question there? And I know my trust says that it's a New Hampshire trust governed by the laws of New Hampshire. Is there any problem here? Do you see any problem?
Well, let me ask a few more.
They live in Maryland, by the way.
Oh, I was going to say, so.
Getting better. Yeah.
You may have a Maryland tax
Right.
problem. The Maryland
Right.
trusts are administered in Maryland, maybe some of the Maryland tax.
So, I mean, there's some questions, and I'm mindful of time, I'm not trying to duck your
No,
question,
that's
but
fine.
I don't know, I don't know where you live.
Sure.
Okay, and we just found out, we now know where the trust is, that the sole trustee. So I would be worried going back to the New Hampshire statute in terms of whether or not you have a New Hampshire trustee that has its principal place of administration in New Hampshire. So I don't think that that's gonna be, my gut reaction, not knowing a little more of the facts, that I'm not sure you have a New Hampshire trust for tax purposes. So we've got 3 minutes left, Steve, so do you want to quickly run through Connecticut? And we're happy, by the way, we're not trying to show off any questions and answers, but
Why
for
don't
those who are,
I do?
have got a hard break.
Sure, why don't I do Connecticut really quickly, and we'll take whatever questions we can, and I'll just go through the slides. And this is Connecticut is the Hotel California of trust taxation. It is amazing what they do. And again, I'll just go through some of them. The site is in Connecticut. It makes perfect sense. The testamentary trust created by will of a Connecticut resident at the time of death makes perfect sense. But the next one, an inter vivos trust. This is my guy from Connecticut. An inter vivos trust created by a Connecticut resident grantor, including the grantor who was a Connecticut resident at the time the property was transferred to an irrevocable trust. I'm going to add, regardless of where the grantor and the trustee reside after that. So if you are the grantor of an irrevocable trust in Connecticut and a Connecticut resident at the time of the transfer, that trust is subject to tax in Connecticut forever. I thought that was a ridiculous result. We wanted to decant, this is a different client, an irrevocable trust where the grantor was a Connecticut resident out of Connecticut. We've tried everything we could possibly do, and we found this case, again, a Bank of America case. Bank of America does not have a great track record on state taxation issues, unfortunately, for the bank. But this case was Bank of America challenging the change of situs of a trust that was created at the time the grantor was a Connecticut resident, went all the way up to the Connecticut Supreme Court, and Bank of America lost. So this rule is still good law and continues to this day. So there are a few other techniques that you can do to get appreciation and other things of an irrevocable trust created while the grantor was a Connecticut resident, but be careful of those rules.
And you don't want to go there, but there are a couple cases in other jurisdictions that suggest that it's unconstitutional. Again, I don't think you're going to the Supreme Court on this, that have said that it's unconstitutional. You can't reach trusts that have left your borders, so on and so forth. So
I think that's we don't have enough time to go there, but I think that's an excellent point. I just don't understand how a state can continue to tax a trust that no longer has any connection to that state, any contact to that state. I would love to see, Bill, you need to convince somebody to challenge this. It would be a great case. And then again, the rest of it is just Connecticut resident trust, some of the other issues, and there's a Connecticut Supreme Court case which held that the constitutional basis for Connecticut taxation of an inter vivos trust under the due process clause was constitutional since it was based upon the residency of the beneficiary. So if you have a Connecticut trust with a beneficiary as a Connecticut resident, Connecticut taxation was upheld, and that's not unusual. We see that with other state statutes as well. Just I'll go through the end of the material here. You can see I won't go through all of it. But we have a kind of a checklist / cheat sheet for domicile. We just focused on Mass, Connecticut, New Hampshire, but we could easily add Maine, Vermont, and Rhode Island to this. The schemes are similar, although not exactly the same. The taxation, of course, is very, very different, but we thought that this would be a helpful guide to you. So we're pretty close to our time. If there are any last-minute questions, we'd be happy to take them, of course. Yeah.
If you have say, New Hampshire trust, where the trustee and the trustee advisor say are in Maryland, if jurisdictions does not, the interest in the dividends and so on, I think there's a foreign tax credit mechanism, foreign state tax credit mechanism that prevents double taxation?
Well, if there's the New Hampshire interest and dividends tax does not apply to irrevocable trust, so hopefully there's no 5% tax. New Hampshire has no credit for taxes paid by another state. You truly is the bill.
What about, let's say, Massachusetts and Maryland? The sense of that, there would be perhaps a foreign tax credit mechanism there.
I don't know the law of Maryland, but I'm not sure that there may be someone else, one of you tax guys and gals in the crowd may answer this, but I don't think there is a credit against Massachusetts taxation for trust taxation purposes for taxes paid in another state. There's a deduction.
So there could be double taxation.
Right. That's my view, right? I mean, you would get a deduction for it, but I don't think you get a credit. But yeah, great.
You mentioned professional advisor, location, team.
We're very sensitive about that, by the way. Yeah.
And so that's why I thought I'd ask a tough question. Is McLean, Massachusetts, New Hampshire, or both?
Funny you should ask. So, so this guy runs the department. So here's
your name.
Yeah, that's it. So when we work on when we service.
I'm sorry, McLane Middleton.
Yeah, McLane Middleton, which I will say every single time we say McLane Middleton. When we work on New Hampshire trust matters, we work on it in New Hampshire, and we even take care to meet people in New Hampshire and have New Hampshire employees work on it. Yes, we're paranoid, but we really take great care, and we're working on Massachusetts matters. We work on it here, and yes, I keep a calendar that says where I was every single day.
And I think we're also very sensitive to that from an asset protection point of view. New Hampshire, and so if one of us is a trustee of a New Hampshire Asset Protection Trust, and here we are at Trade Center, and the sheriff walks in, I think we want to be able to say, we've had no administration, we're wearing a different hat here. So it's not only from a tax science point of view, but it's also
That's a great point.
from a civil litigation point of view.
Great.
Molly?
Would a state ever say, like Massachusetts, and a Mass resident moved to New Hampshire and they did all these things, that you listed, the gotchas, would Massachusetts ever write a letter saying you're officially out? Like, how do you know if you're
Oh, it's the most
officially
unsatisfying resolution of a matter of all time. Yeah, so no, they never write you a letter that says you're right. If you are right, and again, and I should have covered this earlier, but the burden, of course, is on you, the taxpayer. They can just stand back. At the end of it, if you win the case, they just send you a letter saying that there is no change to your tax return. It does not immunize you from a subsequent audit.
And I think what, clearly, to your point, you're really moving out or want to take that position, and you check on your mass income tax return that this is a final year. So in theory, you're starting the statute to run on that year, but they're correct their position. Well, the next year, you're a non-filer. So you didn't start the statute in the subsequent year, so we're not going to opine on whether or not you're in Massachusetts more than 182 days or not. At best, you're going to get the statute running on that year.
Right.
And that can change from year to year, so I think I'd be amazed if Massachusetts would be willing to give a definitive statement, because it's only good for a point in time.
Right.
Morris?
Do you advise your clients to write a letter or check the box and say, this is my last year as a Massachusetts resident? Or would you advise a client to simply return and put all zeros? What do you tell your people to do when they're leaving Massachusetts?
I would say to check the box return as opposed to, and then I wouldn't have them file any returns, but actually, I don't know that.
I would do the same thing. I would not file a non-resident $0 return. I think I'm not sure it actually starts the statute of limitations if there was no.
And it simply triggers somebody.
I like
somebody
being
to
off the
review.
radar screen. When we're out, I like to be all the way out.
So, but you would check the final year, this is the
Yep.
final year?
Yep. very much for coming. We'll be around here a while.